Well, in truth, in all the attorney discipline cases over the last 2 years, I've only been not with the majority on 2 occasions, and that's about 75 different cases. So that's unfair, it's misleading, and it's misleading to the electorate who depend on the honesty of judicial candidates so that they can make their judgment.
Okay, thanks. First question for Mr. Wiggins. Anybody have one for Charlie? Anybody on the phone have a question? Karen.
Charlie, when you decided to run, you were aware that it was going to cause us as an organization a lot of heartache. How do you feel about that now that you've gotten into the campaign?
Well, when you make a decision to run, you look at who you're going to run against, obviously. I certainly didn't look at this in terms of causing heartache or frankly sparing heartache to anyone. I looked at this in terms of who I thought, the judges who were up for election this year, who I thought had some problems, and that was Justice Sanders. Let me give you an example of that, Karen. Justice Sanders has just said that the statistics that I've quoted on attorney discipline cases are wrong. I don't agree with him at all on this. They're on my website, it's a list of cases there, and I don't see that he's only disagreed with the majority in 2 cases over 10 years. To the contrary, what I see is that he has voted, if you look at the non-unanimous cases in attorney discipline, Justice Sanders has voted against the discipline recommended by the disciplinary board in favor of the lawyer over 90% of the time. That's just the way it is. Those are statistics. That's a matter of record. And I think that's problematic. And I'll give you an example of one of those cases. It's the case of discipline of day. A lawyer who was convicted of the felony of child molesting an 11-year-old former client. The kid was a client of this lawyer when he was 9 years old, and eventually developed a relationship with the lawyer, and the mother trusted the lawyer because he had represented him. He was convicted of the felony of child molesting, sent to prison for 5 years to life. The hearing officer recommended disbarment. The disciplinary board unanimously recommended disbarment. 8 judges on the Supreme Court recommended disbarment. Justice Sanders disagreed. He didn't think the guy should be disbarred for that. He thought he should only be suspended. The maximum period of a suspension is 2 years. That's an example. You can look at the cases and see that that's there. I think that's probably timing.
Response?
Well, I have all of the orders in discipline cases right here on the table for the last 2 years, and what I said is true. That there's been, I think it was 33 cases in 2009, about 45 in 2008. I've been with the majority in every one of those cases except 2. Now, and when Charlie says that 91% of the time, I just don't know what he's talking about. And neither do the people of the state of Washington when he comes up with this misleading statistic. In the case Discipline of Day, that was a 2007 case. And I did dissent from the majority opinion that would have disbarred this guy because the recommended sanction pursuant to the ABA standards is suspension. And I pointed that out in my opinion, why that was the appropriate sanction, because I was attempting to adhere to the law, adhere to the practice that the Supreme Court has adopted these recommended sanctions. Also, Charlie hands out a sheet, not to this group, but to other groups, and he says that this guy molested his 11-year-old client, which is false. He wasn't his client. He was a former client, and that makes a lot of difference in attorney discipline cases, because the discipline is always tougher if your misconduct involves your own client. So there's another misleading remark about this. But I personally don't put much stock in statistics. What I think judges should do is decide each case by its own facts and its own legal principles. And I'm not a cop trying to fill a quota of tickets. I'm there to give justice to everybody that comes to the Supreme Court.
Okay. Question for Justice Sanders.
Actually, my question, I think, was more directed to Charlie, so I'll wait for the
Okay.
next.
Do you have a question for Justice Sanders?
I do. Please don't read any bias one way or the other into this, but I have a soundbite, slightly better than soundbite level of understanding of the use bond situation. And so my question would be, generally, as a justice, to the extent that you can speak to this, do you stand by the situation as it was raised, and is that something that, as a justice, would be handled the same way in the future?
Well, in this sheet that I passed out, there's an extended explanation. I think it's from Yusufian, that's what he pronounces his name. Mr. Yusufian, shortly before the referendum on the Seahawks Stadium, requested studies from King County. Ron Sims was saying the studies indicated a lot of economic benefit to King County if the stadium was publicly financed. Mr. Yusufian requested those studies and didn't get them for a number of years. Ultimately went to trial. There were many, many findings that showed that this was a very, very aggravating case. It went up on appeal several times. There was an appeal that was heard by the state Supreme Court in 2004. I wrote an opinion on that appeal. It was a concurring opinion where I said that under the facts of that case, Mr. Yusufian should have been awarded at the high end of the penalty scale. The case was remanded back down to the trial court pursuant to the direction that the trial court exercise its discretion based upon a number of non-exclusive factors which were set forth in that opinion. This was before I had any case of my own pending. I took a tour of the Special Commitment Center in 2003, made a Public Records Act case after that requesting documents and emails primarily from the Attorney General. Many of them were withheld on a claim of exemption. Mr. Yusufian did not encounter any resistance on a claim of exemption. He encountered a stone wall. So I filed my suit in 2005. In 2006, I advised Nan Sullins, the ethics advisor for the Washington State Supreme Court, that I had my own Public Records Act case pending, should that cause me to recuse in any other Public Record Act cases. She said, no, Justice Sanders, it's like if you were getting a divorce, that doesn't mean you recuse in all divorce cases. So I did not recuse. I continued on, and then later on, this Yusufian case was randomly assigned to me to write another opinion, which I did write, and which was substantially the same as the opinion I wrote back in 2004. There's no factual similarity between these two cases, and I cannot stand to benefit at all. I know Mr. Wiggins says that these are substantially similar and they directly benefit, that they would directly benefit me, but if you read the opinions that I've written, they were a list of non-exclusive factors based upon entirely different facts, and the Attorney General filed a brief in my case saying that my opinion would not benefit me at all. Besides, my lawyers have the case on a 100% contingent fee, so I can't possibly profit out of that case. The newspapers, it was interesting how the newspapers handled this, because on one occasion there was a motion filed. The newspaper reporter called me up to ask me about the motion that was filed prior to the time the motion was filed, which leads me to believe that there was some manipulation going on and that somebody was playing the papers in order to benefit them in their own case. So, I didn't do anything wrong. I'm proud of the opinion I wrote in the Yusufian case, and that's that.
Response, Charlie?
I think that a justice of the Supreme Court should be able to make a judgment about whether it's appropriate to sit on a case instead of relying on a staffer within the office of the administrator for the courts. And I also would say that Justice Sanders' lawyer in that case, that he had personally cited his opinion to the Court of Appeals. So apparently thought that it had some relevance. If you applied the standards in Justice Sanders' opinion in the Yusufian case to his own case, it made a huge difference in the amount of the penalty. You know, there's law in this. It's U.S. Supreme Court law. Not too long ago, the U.S. Supreme Court, and within the last decade or 2 decades, decided in a case